It is my pleasure to welcome the presenter, Professor Monsignor Michael Xavier Leo Arokiaraj, and all the participants in our webinar, organized jointly by our Faculty of Canon Law, the Canadian Canon Law Society, and the Center for Canonical Services. I'm now very much happy and honored to introduce our presenter of the webinar today. Monsignor Michael Xavier Leo Arokiaraj holds a doctorate in canon law from Pontifical Urban University, Rome. Immediately after his doctorate, he was called by the Holy See to join her Judicial Services in 1996 and became a Rotal Advocate in 1998. Later, he became the head of the Chancery of the Roman Rota from 2000 to 2007, and on 25th April 2007, he was appointed a judge of the Roman Rota. He has been a professor of jurisprudence at the Rotal Law College of the Roman Rota from 2010 to 2013, and from 2013, a professor of Praxis iudicialis of the same Rotal Law College. He is also a commissioner for the Ratum et non consummatum cases at the same Roman Rota from 2013. On 27th August 2014, he was appointed by Pope Francis as a member of the Special Commission for the Reform of Matrimonial Procedural Law, from which resulted two of those famous documents on marriage procedures, Metis Iudex Dominus Jesus for Latin Church, and Metis et Misericors Jesus for the Oriental Churches in 2015. Based on his vast expertise at Roman Rota, both as advocate and judge, he is presenting today's webinar on recent Rotal decisions in penal cases. Monsignor Leo, most welcome, and thanks a lot for accepting to present this first webinar of our faculty for 2025. The floor is yours.
So thanks to you, Father Pudu, and thanks to all the participants of this webinar. Welcome to each and every one of you, and thanks to each and every one of you. The topic is, as you know already, the recent Rotal decisions in penal cases. So now the contents of my talk, you can see it on the screen. Introduction, the notion of delict or crime and its elements. The third, some crimes and the Rotal decisions, then the conclusion. So now the introduction. Every year at the Roman Rota, we deal with few penal cases only. Maximum, as you can see in the every year's column, for example, 2013, 5 cases, 2023, that is year before last year, 10 minus 1 cases, 9 cases. So maximum 9 cases in a single year. That's why, to substantiate my affirmation, I have given you the recent statistics of the pending cases at the end of every year, starting from 2013 till 2023. So, as you can see again, 2013, 5 cases, the following year, 3 cases, following year, 1 case, 2016, 2 cases. And I would like to underline the fact that these are not incoming cases, but pending cases. So the following year, 2 cases, then 2018, 5 cases, 2019, 6 cases, 2020, 7 cases, then 4 cases, 6 cases, then year before last year, these cases that you see on the screen. Always below 10 cases, 9 cases the maximum. Why do we have so few penal cases at the Rota, while we have hundreds of marriage cases? The answer is, some penal issues are resolved in the extrajudicial way. You can refer the canons 1341 and 1342. So they are dealt with the penal administrative process. So in the extrajudicial way, they are resolved. And or they are sorted out at the local level and so do not come to the ordinary appellate court of the Holy See, that is the Roman Rota. For example, an affirmative sentence in the first instance. The accused accepts the sentence, so he does not appeal, so it doesn't come to us. Or a negative sentence in the first instance, and one who accuses the promoter of justice, he does not appeal. So the case is over there. So we do not get appeals from the local forum because of these motives. Then dicastery for the doctrine of faith has the exclusive competence to deal with the delicta graviora, that is very, very grave, serious delicts. Then delicta contra fidem and contra mores, that means delicts, crimes against faith and against morals. The next. And some other dicasteries, like those for the clergy, dicastery for the consecrated life, dicastery for the family and life, dicastery for the culture and education, the apostolic penitentiary, that is the internal forum, and the tribunal of the apostolic signatura, deal with the recourses in the penal and disciplinary matters according to their competence and or the faculties conferred through the administrative process. Lastly, we can say that many Catholics are not aware of the penal code of the church, and some others do not even report to the authorities the crimes that occurred to them or to their brethren, either out of ignorance or out of fear, general fear, and or reverential fear. Hence, already at the local tribunals, we have very few penal cases. The next. Hence, the Rotal decisions on penal matters are evidently so few that it might even seem difficult to delineate a true jurisprudence in the classic sense. However, the decisions handed down by the Rotal judges are of increasing interest for the in-depth study of the issues dealt with. It's therefore thought that the knowledge of them could be useful to students, practitioners, scholars, especially since a certain consensus seems to be forming on certain topics among the various panels of judges that have dealt with the penal issues. So that is the introduction. The second, notion of delict and its elements. While the Code of Canon Law, we can say the older Code of Canon Law, that is of the year 1917, gave us the definition of delict. The old Code of Canon Law of 83, why old Code of Canon Law of the year 83? Because for the penal law, now we have a new code, the Liber Sextus, the sixth book is new, it has been reformed. So even the Code of 83 is old with regard to the penal laws. So the old Code of Canon Law 83 does not give us that definition, but its essential elements implicitly emerge from the Canon 1321, and also from the new sixth book of the Code of Canon Law. These essential elements implicitly emerge from the same canon. The number is the same. The objective element of a delict, crime. The objective element involves the external violation of the law or norm. That is, an external physical act that causes harm to society. This act is required to be external, that is perceivable if there are other persons present. Internal acts such as heresy, not manifested to anyone because it remains in the internal level in a particular case, for example. These internal acts are not punishable under penal law. And every external act is always perceptible, even if no one is present, it's perceivable, perceptible. And in this case, we have the figure of the occult or hidden crime. The subjective element, there is a subjective element when the person has previous knowledge of the law and intends to violate it. In other words, the following are required: knowledge of the object and the agent's actual intention to place the known act as contrary to the law. This is the subjective element. The subjective and objective elements, they are explained in a sentence. Coram Monnier, he's a French Rotal judge. The sentence is of the date, you can see it on the slide, of the year 2002, the month June. So he explains the objective element like this: externa violatio legis, ex dolo seu actu deliberato, seu ex omissione debite diligentiae. So he explains the objective elements in this sentence in number 5. In number 7, the same Monnier, in the same sentence, in number 7, he explains a subjective element, that is the imputability. That is cognitio obiecti, the cognition of the object, and the voluntas et voluntas actualis ponendi actum contra legem. So the cognition of the object and the will, the actual will to place the act against the law. This is the subjective element. Then there is a legal element, juridical element. The canon for this, you can refer this canon 202-1, the last paragraph. Then in the sentence Coram Caberletti of the 9th March 2021, Caberletti explains this juridical legal element. The canon 221, the last paragraph says, the Christian faithful have the right not to be punished with canonical penalties except according to the norm of law. So without the law or the norm of law, there is no punishment. The law should prescribe the punishment. So the third element is juridical legal element. The Rotal jurisprudence on the subject of the legal element indicates that it is to be considered null and void a conviction based on norms that do not have penal nature, but at most disciplinary, merely disciplinary. So the sentence, there is a sentence Coram Ega Sabul Extensore of the 4th March 2015, number 11, that says that any conviction is to be considered null and void if it has been based on norms that do not have penal nature. That means nulla pena sine lege penali. So if there is no penal norm or penal norm, there is no punishment. So the legal element is very important for the penal law, for the penal sentences. Then the material element, Coram Caberletti of the 31st July of the year 2014, he speaks about the material element saying that violatio legis externa esse debet in opposizione ad violationem mere interna. So it should be material. The violation of the law must be material. It must be objective. It should not be internal or spiritual, hidden within your heart or within your intention. It should be the material element is again the objective element. Then Cora Mackay of the sentence of Mackay of the year 2010 of the month July that you see on the monitor in the slide. He talks about the specificity in the presence of several potentially applicable penal norms. The criterion of specificity must be applied. For example, in the case of an abortion, though it normally falls under the category of murder or homicide, the canon, you can refer the canon 1397, now the new penal law, the new sixth book, canon 1397, paragraph 1. So in case of an abortion, though it normally falls under this canon, under the category of murder or homicide, the judge, in accordance with the canon 1398, now it's canon 1397, paragraph 2, the judge must declare the penalty late sententia. So the criteria of specificity, because there is a specific norm for abortion, you cannot put it under the common general category of murder and homicide. The judge must declare the punishment according to the particular norm, that is 1397, paragraph 2. The punishment for the specific crime abortion is mentioned there. So the criterion of specificity is very important. Then the last point is fragmentariness or fragmentarity of the penal law, with particular reference to sexual offenses. You can refer the sentence Coram Arokiaraj. It's my sentence of the 15th July 2020. There I have explained this point. Not all sins committed by clerics against the sixth commandment of the Decalogue are automatically delicts. They are not automatically crimes. That is to say, they are not punished by penal sanction. Not all sins committed by clerics are punished by penal sanction. In fact, penal law is governed by its own principles, among which there is one that the secular doctrine calls the principle of fragmentarity or fragmentariness, for the tenor of which only some actions or at times omissions particularly harmful toward the public good or the social order are chosen by the legislator as deserving penal sanction. So only the fragments, not all the sins become automatically penal. Only those who have been selected by the legislator. So this is called fragmentarity or fragmentariness. So the next slide, aggravating and mitigating elements. A sentence Coram Eger of the, you can see in the monitor in the slide, of the year, the month June of the year 2016, sentence of Eger offers a candidly didactic exposition in this regard, that is regarding the aggravating and mitigating elements. This decision refers in particular to the aggravating circumstance of the abuse of authority or office. Canon 13-26, paragraph 1, number 2. For example, a judge must inflict a more serious punishment than the prescribed, that a judge must inflict a more serious punishment than that prescribed in the law when a person, for example, after being condemned, continues to offend, so he must be seriously punished, more seriously punished. So this is an aggravating element. If a person, if even after being condemned, he continues to offend, if he continues to violate the law, then this is an aggravating element, then he must be more seriously punished. Or a person who is established in some position of dignity, or who, in order to commit a crime, has abused a position of authority or an office, then he must have a more serious punishment, because these are aggravating elements. With regard to the extenuating circumstances, a sentence, you can see it on the monitor, sentence Coram Kabarlethi of the 9th March 2021. This sentence took into consideration drunkenness as a mitigating element, drunkenness, although then in the argument section, the sentence did not consider it applicable, as the state of alteration caused by alcohol was claimed only by the offender and not proven by the other sources. So this extenuating element could not be considered in that particular case. Then the next, functions and determination of the punishment. A sentence Coram Excellentísimo Aureliano Cedillo, now he's the Dean of the Rota, of the 7th July 2021, exposes the functions of the punishment, retributive, preventive, general and special, on the basis of the classical doctrine. The punishment imposed in the sentence must always be certain and specific, and it cannot consist of advice, wishes, or exhortations, as stated in a sentence Coram Vaccaroto Eger Extensore. You can see it on the monitor. See, Coram Vaccaroto means the case was in front of the ponens Vaccaroto. Eger Extensore, but one who wrote the sentence, one who extended the sentence in law section and in argument section is Eger. So it's a case of Vaccaroto, but the sentence was written by Eger, who was in the turnus. The date, you can see it on the monitor, of the year 2015. So the punishment should be very certain and specific. It should not be of mere advice or wishes or exhortation. In determining the punishment, according to the judgment Coram Excellentísimo Aureliano Cedillo of this, no, not this slide. Yeah, yes, correct. In determining the punishment, in the same sentence of Aureliano Cedillo, according to this sentence, also the limitations imposed ad cautelam, already imposed on the offender before condemning him, these precautionary measures must be taken into account when you give the final decision. For example, as it happens in the United States of America with the so-called administrative leave. This is the concrete example we give. Indeed, in a sentence Coram Eger, Sebul Extensore of the 4th March, I already cited this sentence of the year 2015, it's rightly observed that the administrative leave rather resembles a suspensio divinis. It's already a suspension ad divinis, forbidding the person to celebrate the sacred functions, for example, sacraments, for example, Mass, which the priest in the particular case, Coram Eger, the priest has been undergoing for almost 12 years, because that limitation was imposed as the cautelam, as a precautionary measure on that particular priest. So it is to be considered as a serious penance, 12 years of not being able to celebrate the Mass, Holy Mass. So when you pass the final judgment, you must take into account all these years passed as a punishment period. In this matter, the penal code in force in Vatican city-state, so the civil code, so this in the civil city-state, the penal code in Vatican city-state, because it's for the crimes committed in the Vatican city-state. So that penal code in force in Vatican city-state contains a similar norm. For example, Article 40, Article 40, it says the imprisonment suffered before the judgment has become irrevocable shall be deducted from the total duration of the penalty restricting personal liberty. The Roman Rota, in absolving an offender, not because the sinful act does not exist, but because it does not constitute a crime, does not fail to remind the respective bishop or ordinary the other means of correction that the system places at his disposal to provide for the good of the offender himself and of the community. This is from a sentence coram milite eger extensore of the day 26th of July of the year 2022. Coram milite. So when we absolve an offender because the sinful act does not exist, because not because the sinful act does not exist, but it does not constitute a crime. So we have to absolve the offender, but we do not fail to remind the bishops and the ordinaries. We do not fail to remind the other means of correction that the system places at the disposal of the bishops, or the ordinaries, to provide for the good of the offender himself and of the community. Then the next topic, some crimes and the Rotal decisions on them. First one, incitement to hatred towards the church. Canon 1369, now 1368. A sentence coram eger of the 28th June 2016 deals with the subject of crimes of opinion. Reflections also applicable to other offenses such as incitement to hatred towards the ordinary and defamation. Canon 212, paragraph 3, definitely recognizes to the faithful the right and sometimes the duty to express their opinion on matters that concern the good of the church in proportion, however, to the science, competence, and dignity that each enjoys, and without damage not only to the integrity of faith and morals, but also to reverence towards the pastors, and without neglecting the common utility and dignity of people. Then B, disobedience to the ordinary. Canon 1371, paragraph 2, now 1371, paragraph 1, according to the new 6th book. Here, a sentence coram bunge. He's an Argentinian judge, Rotal judge now. Coram bunge of the 22nd June 2021 considers that this delict was integrated by the conduct of a priest, also condemned under Canon 1395, paragraph 1, for scandalous persistence in the sin against the 6th commandment, who disobeyed the precautionary measures subsequently imposed on him to publicly exercise the ministry and to present himself as a priest. He disobeyed, so he was punished. Then the Then C, incitement to hatred towards the ordinary, Canon 1373. The already cited sentence quorum Msgr of the 28th June 2016 specifies that unlike the norm of Canon 1370 paragraph 2, which incriminates the physical violence exercised against the person of the bishop, Canon 1373 protects the freedom of the function of ordinary and the effectiveness of its acts. Therefore, this protection extends not only to the bishops, but to all the ordinaries envisaged in Canon 134, for example, the military ordinary, and the one in charge of the ordinariate constituted in accordance with Apostolic Constitution Anglicanorum Cetibus. Then the illicit alienation of ecclesiastical goods, Canon 1377, now Canon 1376, paragraph 1, number 2. A sentence quorum Mackay of the 23rd July 2010 underlines that although in all the contracts where a deterioration of the patrimonial condition of a legal entity may occur, the legal formalities required for alienation must be observed. There must be, however, no confusion between those contracts and this alienation, especially when it comes to making a conduct a delict. So we should not confuse the contracts with the illicit alienation. Alienation should be done according to the law, but if it has been done illicitly, then this illicit alienation that becomes a crime, that is punished, not the whole contract. So we should not confuse the contracts with the alienation, with the illicit alienation. Then the next one, abuse or negligence in the exercise of the office. Next, please, Father Pudu. Abuse or negligence in the exercise of the office. The old Canon 1389, present Canon 1378. I have to say it also the old Canon because they are all from the sentences that were given before this new reform. So I have to say the old code, the old Canon according to the old code in the sentence, but I have already updated with the actual Canon. So I say the Canon 1389 in the sentence, then the present Canon 1378. In a sentence quorum Mackay of the 20th June 2011, a parish priest was convicted also for the attempted marriage from which 3 children were born, who had systematically embezzled the offerings of the faithful to maintain his illegitimately constituted family. This sentence, this decision highlights the moral obligation for the offender to return the sums of which he has appropriated. The defamation, now the same canon, Canon 1390, paragraphs 2 and 3. A certain uniformity can be broadly considered to have reached in the classification of the concepts of injuria, sometimes also called contumalia in Latin, so injuria, which indicates the offense to honor caused to someone in person or by a written or other communication directly addressed to the victim, and of diffamatio, which instead indicates the injury of the good reputation of someone made in communication with third parties. So we can understand the difference. So the offense made directly to the victim. The next category is offense made in communication with third parties about the person, but with third parties. So these are the main classifications. First is injuria. The second one is diffamatio. This diffamatio, so defamation, has two subspecies. That is calumnia, when the person is falsely attributed dishonest facts. When the person is falsely attributed dishonest facts. This is called calumnia. Then the second subspecies is detractio. That is when real but occult moral shortcomings are revealed. So these are the two subspecies of defamation. That is, the first one is the person is falsely attributed dishonest facts. The second one is detractio, that's real but occult moral shortcomings are revealed. A sentence Cora McCain, yeah, you can see it on the monitor, of the 18th February of the year 2013, rendered in a contentious case, restitutionis bone fame, that is the restitution of the good name, referring to the Catechism of the Catholic Church published in the year 1992, which codifies the aforesaid distinction, summarizes the theological basis of this crime. To integrate the crime of defamation, the subjective element, generally referred to as animus diffamandi, the subjective element, this subjective element is required. In addition to the typical fact, an expression or representation detrimental to the good reputation of others, addressed to at least one subject other than the defamed, and the anti-juridical nature of the conduct resulting from the absence of causes for its justification. It can be observed in jurisprudence that the non-recurrence of the crime is from time to time caused by the defect of the subjective element, that is animus diffamandi, or alternatively by the presence of a discriminating cause, characteristically the exercise of a right and or the fulfillment of a duty of office, which invests more properly the same objective element, that is the good reputation. The jurisprudence clarifies that there can be no crime if the objective element, that is of good reputation, is absent, in case it has already been lost by the offended party. It is linked to that of exceptio veritatis, which more properly should qualify as a cause of exclusion of punishability. This is in a sentence coram ege. You can see it in the monitor, the last line of the 28th June 2016. With regard to the punishment to be imposed, the new rule has specified that we should apply an expiatory penalty pursuant to Canon 1336, paragraphs 2 to 4. That is prescription, prohibition, and deprivation, to which a censura may be added. In this regard, the same sentence coram ege, just now cited, has significantly observed that even formally expiatory penalties can be imposed with medicinal intention. The next slide, please. A fact that can be considered consolidated in the Rotal jurisprudence is the autonomy of the compensatory contentious action with respect to that of the penal one. In fact, several judgments have been delivered in urium cases, not in penal cases, in urium cases, and only incidentally there has been cognizance of the offense, the crime. for the sole purpose of declaring compensation liability. In one case, for example, in one case, Cora Mackay of the 18th February 2013, the respondent was a bishop, and therefore the Rota would have been absolutely incompetent to judge him in penalibus, in penal cases, by virtue of Canon 1405, paragraph 1, number 3. So, if you bring a case against a bishop, accusing the bishop of this and that crime or offense like that, and you ask also for the restitution of the good name, of your good reputation, the Rota separates the criminal case because we are not competent to deal with the criminal cases against the bishops. So we take into account the offense of the defamation against the good name. The cognition of the offense is there, but we don't deal with the penal section, with the penal case. We don't go ahead with the penal case, but we take into account this fact in order to decide on the compensatory contentious action, that is the restitution of the good name. So only for that we decide whether the bishop has to compensate for the good name, whether he has to restitute the good name of the party. So only that we decide, not on the penal case against the bishop. We are not competent. Then ideological falsity in a public ecclesiastical document. That's falsehood in a public ecclesiastical document. Canon 1391, number 3. With regard to the crime of ideological forgery in a public ecclesiastical document, that is the forgery related to the content of the document and not to the document materially understood, the sentence Cora Mackay that you can see on the monitor, the sentence Cora Mackay of the 20th June 2011 clarifies its moral and juridical foundation and some conducts that lead to that crime. The next slide. Attempted marriage, Canon 1394. In the same sentence, Cora Mackay of the 20th June 2011, the punishment imposed in consideration of the offender's insensitivity to the warnings received and the absence of any hint of regret on his part, the penalty imposed was that of dismissal from the clerical state. Then concubinage, Canon 1395, paragraph 1. The crime against continence imposed on clerics represent an important part of the penal cases at the Rota. Indeed, the quantitative difference with respect to the past, when the crimes against morality occupied a much smaller part, this quantitative difference now with respect to the past leaps to the eye. We have many, many cases. So maximum 9 cases per year, as we have seen. But in these 9 cases, many cases are of this kind. So the crimes against continence imposed on clerics represent an important part of the penal cases of the Rota. In particular, with regard to the crime of concubinage of clerics, the Rotal sentences have defined its contours, especially in order to differentiate it from any heterosexual custom, even continuous, which does not, however, present the formal element of a stable consent to the reciprocal use of bodies for the purpose of erotic satisfaction, similar to what happens in marriage. A sentence, Cora Mackay of the 14th May 2009, After a substantial review of authoritative doctrinal opinions, summarizes the legal profile of the crime of concubinage. The next slide, please. Scandalous persistence in external sin against the sixth commandment, Canon 1395, paragraph 1. A sentence coram Huber of the 26th of February 2010 explains the constituent elements of this delict as follows. First one is peccatum externum. Id est modo physic oppositum, then peccatum permanens, id est cum violatio legis penalis, clericum in conditione permanenti constituit, et in simul in communitate scandalum creat. So there must be an external fact, external sin, external crime, external delict, done in the physical sense, and it's permanent, peccatum permanens, permanent one. Then it should create scandal in the community. So these elements are necessary to constitute this crime under this canon. With reference to the material element of external sin, a sentence coram Pinto of the 19th December 2003 embraces a rather restrictive doctrinal opinion which recognizes relevance only to sin consumed with copulation in acts according to nature. Kissing, touching, mutual masturbation, etc. are not sufficient to constitute this crime, according to the sentence of Pinto. But other sentences consider that for the typification of external sinful conduct against the sixth commandment, reference should be made to the offenses against chastity listed in the Catechism of the Catholic Church, as further specified in the Vademecum of the Congregation, now Dicastery for the Doctrine of Faith of the 16th July 2020, equipped with appropriate explanatory value. The offense referred to in the second part of the Canon 1395, paragraph 1, although close to concubinage and like it characterized by permanence, differs from it in the major vagueness of the incriminated conduct and in the necessary presence of scandal as an objective condition of punishability. A detailed reconstruction of the case history can be found in the sentence coram Baccarotto, Jaeger Extensore of the 23rd June 2015. Here it is clearly established that the scandal as a condition of punishability must be concomitant, that is, accompanying the continuance of the crime, whereas the scandal aroused subsequently is not to be regarded as confirming a punishable offense. Correctly, a sentence coram Arokiaraj, it's my sentence, of the 17th March 2021, warns against confusing permanence with recidivism in the crime against the sixth commandment. Next slide, please. Crimes against the sixth commandment committed with the violence or threat or publicly. Canon 1395, paragraph 2, now Canon 1395, paragraphs 2 to 3. In the previous formulation, Canon 1395, paragraph 2, declared a cleric who committed a crime against the sixth commandment of the Decalogue punishable by a just punishment, not excluding, where appropriate, dismissal from the clerical state if the crime was committed with the violence or threats or publicly or with a person under the age of 16, the old code of 83. Now, according to the new 6th book, it's 18. The age limit is 18. The sexual offenses against minors have now been reserved to the jurisdiction of the congregation, now dicastery for the doctrine of faith, by virtue of the motu proprio sacramentorum sanctitatis tutela of the 30th April 2001, the year 2001. At the Roman Rota, in the period before the competence of the dicastery for the doctrine of faith, there were only 2 cases. So we have only 2 sentences at the appellate level. In both cases, the trial had begun at the ordinary court before the special legislation came into effect. The sentences, these 2 sentences, however, do not present any significant in-depth study of the law in relation to this specific crime. In the new formulation of Canon 1395 in force since the 18th December 2021, paragraph 2 covers only the crime committed publice, that is publicly, while the 3rd paragraph includes the hypothesis of the crime committed with the violence or threat, this is new, with abuse of authority, this is new. The material conduct indicated in this paragraph includes both the commission of an offense against the 6th commandment and the coercion of someone to perform or submit to sexual acts. Sexual crimes committed against minors are now covered in Canon 1398 and more correctly placed under the heading of crimes against human life, liberty, and dignity. The jurisprudence on the previous formulation of the Canon 1395 paragraph 2 can certainly find a fruitful field of application in relation to the new formulation, that is Canon 1395 paragraphs 2 and 3 of the Canon 1395. First of all, it should be emphasized that unlike the sexual offenses examined so far, the offenses with which we are now concerned are consummated also by a single act, provided it is committed in the manner indicated by the law, for which permanence or habituality is not required. You can refer the sentence Coram Huber of the 26th February 2010, number 5. With regard to the possible material conducts constituting the crime upstream of the violent or public manner in which it's committed, violence or threat publicly, a reference should be made once again to the judgment Coram Arokiaraj of the 17th March 2021, which distancing itself from the more restrictive view according to which an act similar to a conjugal act would be required. Coram Arokiaraj states that the delictum contra sextum minime significa tantum od actum coniugali similum ponere, penetrationem scilicet et eiaculationem consummare, portius a typificationem delicti quod attinet, remissione in primis facta dieas quae contra castitatem offense in Catechismo Catholici Ecclesiae recensentur, and in the instruction of the Congregation for the Doctrine of Faith, recently cited, the Vademecum. So now the Vademecum of the Congregation and the Dicastery for the Doctrine of Faith explains very well what constitutes this crime. It explains thus: the delict in question, the crime under discussion includes any external sin against the 6th commandment of the Decalogue committed by a cleric with a minor. The typology of the offense is very broad and may include, for example, sexual relations, consensual, non-consensual, physical contact of a sexual nature, exhibitionism, masturbation, production of pornography, inducement to prostitution, conversations and or proposals of a sexual nature, also by means of communication. Regardless of, these have been explained clearly in the Vademecum of the Dicastery for the Doctrine of Faith. Regardless of the fact that these behaviors are listed not peremptorily, however, in the specific area of offenses committed to the detriment of minors, they may well be considered as examples of actions qualifying as criminal offenses in the recurrence of the other legally codified elements, even when carried out with persons of major age. Then crimes committed publicly. There are two different jurisprudential opinions in this regard. The first understands the publicity of the crime also in a subsequent sense, that is, by virtue of the posthumous disclosure. The second interpretation, on the other hand, strictly requires simultaneity in the sense that the same criminal conduct is publicly committed. The latter requires the actual publicity of the crime. The former considers that even merely virtual publicity is sufficient. The sentence Coram Huber of the 26th of February 2010 seems to adopt precisely the first of the two aforementioned interpretative options. The other line of interpretation is clearly expressed in the judgment Coram Jaeger, Sebul Extensore, you can see it in the monitor, of the 4th March 2015. This jurisprudence also highlights the conceptual difference between the crime committed publicly and the public crime. So there is a difference between crime committed publicly and the public crime, which was mentioned in the 1917 code, mainly for the purpose of applying certain penalties. The publicity of the crime must be understood as publicity of fact and not merely potential publicity. In the same sense, the judgment Coram Arokiaraj of the 15th July 2020, it says, certainly the publicity of the delict about which the canon speaks is certainly simultaneous, not subsequent, and it is to be intended in the sense that the criminal fact must be of public domain at the very moment it is committed and not later. The time is going ahead, so I have to cut short my talk. Sorry. The next slide, please. In the same decision, Coram Arokiaraj, there is an interesting reflection. Yes, I'll try to cut off very quickly.
I think we have about some 5 more minutes to conclude, maybe, if we can.
I will do it as soon as possible. In the same decision, there is an interesting reflection on the publicity or privateness of virtual places that can be reached through the computer network, such as individual or group chats, which are so widely used nowadays as a way for people to meet. This judgment considers that the principles set out above can be analogically applied, deeming as private those virtual places, groups, conversations, etc., whose access is not open to any internet user but controlled. Then the next slide, please. Crimes committed with violence or threats. With regard to the crime against the 6th commandment committed with violence or threat, the Rotal jurisprudence has made significant contributions. Indeed, it shows that it somewhat anticipates the systematic innovations introduced by the penal reform. Then we can go ahead with the next slide. According to the above mentioned decision, the threat could be recognized at least in an implicit and virtual sense, but nevertheless very concrete, considering the relationship of subjection between the victim and the offender. The woman performed, it's a concrete case, the woman performed cleaning services in the parish where the priest exercised his ministry. The object of intimidation could in this case easily be identified as the preservation of one's job, an element of such great importance in people's lives to safeguard their dignity. The next slide, please. Regarding the above decisions, reading the above decisions allows one to appreciate the effort made the effort made the jurisprudence to extend the protection of people's freedom and self-determination in such a delicate sphere without ignoring the advances in social awareness concerning these heinous crimes. Then the next slide, please. Coming back to the sentence Xavier Arokiaraj of the 17th March 2021, I would like to underline a matter of great interest. That is, it speaks of the possibility of the judge of the appellate tribunal to re-qualify the crime with respect to how it was framed in the first instance. In this particular case, the court of first instance had qualified the action of the active subject under Canon 1395, paragraph 1, while the Rotal Turnus, the Rotal Panel of Judges, considers that it should be classified under Canon 1935, paragraph 2, the old code of 83, of the year 83, as a crime committed with violence and threats. This sentence justifies the power of the appellate court with the following reasons. Next slide, please. Firstly, by recalling a passage from Laga's well-known commentary, in which it stated that while illustrating the question of fact is up to the parties, its legal qualification, the question juris, is instead the responsibility of the judge. Secondly, it's recalled that even secular systems allow for a rectification or requalification of the charge from the specific point of view of law or of the law violated, that is of the law violated, attributing a different nomen juris to the fact. Then the next slide, that you will get it, Father Pudu, he will send these slides to you so you can read all these things. Then we can go to the next slide, Father Pudu. Serious injuries, sentence Coram Huber of the day 26th February 2010. This judgment recognized the records of the offense of grievous bodily harm against the defendant priest. The violent actions with the resulting injuries suffered by the person on whom the sexual acts were performed appear to have taken place in the context of illicit encounters. In this case, the serious injuries caused by the defendant to the victim are considered proven on the basis of the civil convictions. The punishment imposed for both canonical offenses recognized as proven was dismissal from the clerical state. Then crimes punishable under Canon 1399. This canon makes external violations of divine or canon law of special gravity punishable even outside the typical criminal cases when there is an urgent need to prevent or remedy the scandal. In the judgment Cora Mackay of the 23rd July 2010, it's emphasized that an indictment under Canon 1399 is only to be used when an offense is not already a criminal offense under another norm and therefore cannot be cumulated with any specific indictment. Then conclusion. Sorry for the delay caused to you, sorry. So the Roman Rota, with its institutional function of providing for the unity of jurisprudence, plays an irreplaceable and vulnerable role in this field of orientation, guidance in the judicial protection of individual and collective juridical goods, presided over by penal norms, and with its jurisprudence can provide, as it has historically been in matrimonial matters, impetus for the progress of doctrine and legislation itself. Thank you, and sorry for too much of time I have taken. Sorry.
Monsignor Arokiaraj, thank you. Thank you for sharing with us your profound expertise in this area of very actual ecclesial discussion in the church. Also in line with the latest changes to the new book 6 on penal sanctions of the church and the guidelines that we got of the user guide of the dicastery for the legislative text. Your webinar in a way comes to complete the penal law workshop that the faculty offered in November last year. Your insights have helped us to better understand various aspects of the penal cases at the Roman Rota, especially from the perspective of jurisprudence that could help us in handling better the penal cases. So thank you so much. May God continue to bless you in all your endeavors, especially in your ministry as judge at the Roman Rota. Thank you, Monsignor. A big thanks also to all persons at St. Paul University involved in the preparation and conducting of this session, especially the members of the coordinating committee. Along with me, our faculty's dean, Professor Chad Glendinning, Sister Louise Charbonneau, Administrator of the Center for Canonical Services, and Mrs. Ruth Barreau, the Assistant to Dean and Program Coordinator. Finally, a special thanks to all of you, the participants in this webinar, either live or offline. And today, all those who had registered went over 430. So we are very grateful to you for that. By your presence, you support our initiatives and thus encourage us to continue. So thank you all. Thank you, Monsignor. Goodbye, and God bless you all. Thank you.